Good day and a warm welcome to you. My name is Tammy Barnard, a Senior Dispute Resolution Official in our Gauteng branch. In our previous videos, we discussed the enforcement of compliance orders as well as written undertakings in terms of a compliance order in terms of Rule 31B of the CCMA rules. Today, however, we will be looking at the enforcement of collective agreements in terms of bargaining councils. A bargaining council is a legal entity which is established by one or more employers' organizations or one or more trade unions which are registered in terms of the Labour Relations Act. Some of the key functions and performances of a bargaining council is the creation of a collective agreement in terms of that industry-specific uniform rules, the management of the bargaining council fund, the establishment of dispute resolution, as well as management and training of particular schemes. Section 33 of the Labour Relations Act provides for the appointment of designated agents in a bargaining council to promote, monitor, and enforce compliance with collective agreements within that council. The designated agent may issue a compliance order requiring any person bound by a collective agreement to comply with a collective agreement within a specific period. Should the employer fail to comply with a compliance order, the council may refer the dispute concerning compliance with any provision of the collective agreement to arbitration. Arbitrators have the same powers as those of the CCMA commissioners and may order payment of any amount owing in terms of the collective agreement, impose fines for failing to comply with the collective agreement, charge an arbitration fee, or order a party to pay costs of the arbitration. Confirm may vary or set aside compliance orders issued by a designated agent or make any other appropriate award. Factors to consider, which are very important in terms of complying with the bargaining council and its main agreement, is the following. 1. The status of the main agreement, whether it is valid and binding. 2. The scope of the main agreement. Does the nature of your business fall within the scope of the main agreement? Or 3. If the main agreement has been extended to non-parties, which means that even though you're not a party to the main agreement, you can still be bound by it, as it has been extended to non-parties by the registrar. It is important for you as the employer to know whether you should belong to a bargaining council or not, as failure to do so may have huge financial implications due to the fact of non-compliance may be enforced retrospectively. Ignorance of the law is no excuse, so please contact your nearest CEO office to gain clarity on whether or not you should register with a bargaining council or form part of a main agreement. Thank you for your time, and please like and share our videos.